Well, good afternoon, everybody. Thank you for joining me for the final paper in the final webinar of the series of three, which we put together on the subject of dilapidations. The title of today's webinar is Litigating a Dilapidations Claim, and there are three papers that I'm going to speak to. In the first instance, I produced a paper and I'll speak to it, which concerns preliminary considerations and schedules. I follow that with a paper addressing pre-action protocols and in particular that which applies to commercial property in England and Wales in relation to dilapidations at the end of the term. The final paper is concerned with litigating a dilapidations claim. As always, the papers that I'm speaking to will be sent to every delegate after the webinar is finished. I'm not suggesting immediately, but soon after. And therefore, I won't be speaking to every word that I've written, quite apart from anything else. We only have an hour, which is about the maximum that anybody can do this online, in my view. Again, as always with my webinars, we don't have questions during the presentation. I found that leads to a disjointed presentation and very high risk of the technology failing due to the nut behind the keyboard at this end of things. But having said that, I'm very happy to address any points or questions that arise from the paper. Please feel free to email me at my email address, which is my surname at initial and surname at ninestonebuildings.com. It's written on the bottom of the papers on the Chamber's website, and I'll happily address those issues or questions. I really can't advise on specific cases, but I'm sure you can formulate a question in general terms that you'd like to know the answer to. Talking of which, I don't know if anybody attended the last webinar. I think it was the last one, but I made a comment about limitation and claims under dilapidations covenants, and I put in the paper that it's on a simple contract is 5 years. That's a mistake, it's 6 years. So that's the value of feedback. So if you were there, it's 6 years. There's no 5-year limitation period for anything as far as I'm aware. You'll notice on the PowerPoint slide in front of us that there's a request that you remain muted with your camera turned off during this webinar. I mentioned that orally today because on the last occasion, in error, a delegate left their microphone on, which resulted not so much in disturbance for me because I couldn't hear it, but to other delegates. But more significantly, the subject matter of the conversation that was taking place was not something that should have been broadcast outside the office. So can I invite you to check that your microphones are muted? As for cameras, well, perhaps we better leave those off. I'd only get distracted by the Brady Bunch in front of me. So with that introduction, which went on a rather bit longer than normal, I'll start with the first paper, which I say it's called Preliminary Considerations and Schedules. We've now reached a position where the tenancy or lease is about to come to an end or has come to an end, and the landlord is of the view that there are extant breaches of covenant. Taking a step back, in every case of a landlord and tenant grant, where the tenant is under a repairing obligation, there will be a time during the course of the lease when the tenant is in breach. Even the most punctilious and careful tenant will at some stage be in breach. There'll be a crack in a wall or a soil carpet, or so on and so forth. That is a truism. But of course, in the vast majority of cases, any loss that arises to the landlord because of such a breach is a paper loss, and the landlord doesn't bother itself about it at all. And if you build into that the hoops that often have to be jumped through in order for a landlord to obtain a worthwhile remedy during the term, one understands why it is that claims for dilapidations during the term are rare. Of course, there are exceptions where the tenant's breach is substantial and has the impact of damaging the landlord's reversionary interest in a significant way, or adjoining premises belonging to the landlord, or more commonly, disturbing other occupiers or tenants of a building that is in multi-let. Then, of course, the landlord is obliged to and will take steps during the course of the term. At the end of the term, which is the time we are concerned with, the position is very different. The landlord expects the tenant to have complied with its covenants, and if the tenant doesn't, then the landlord is getting premises back which are not in the condition that the tenant covenanted to hand them back. That's what it says on the screen now. In a good many cases, and it depends upon the nature of the premises, at the end of the term, when there's extant breaches of covenant, the tenant may simply hand back the premises out of repair and buy its way out of its obligation to yield up in repair. And they'll just, the tenant surveyor and the landlord surveyor will get their heads together and they'll try and come up with a figure and to buy out the dilapidations claim. Alternatively, a tenant may attempt to comply with its pairing obligations by carrying out the works and handing the premises back in repair. Even when a tenant takes that second approach, the landlord can pursue a dilapidations claim if it takes the view that the works carried out by the tenant are insufficient, should have repaired the roof and didn't, notwithstanding that it painted the exterior, or that the standard of the works carried out by the tenant is not sufficient to put the demised premises in the condition required by the tenant's obligation. The tenant used cheap wallpaper and cheap paint, whereas the high-class nature of the premises demanded a better product. That's the debate. An example of this third situation, where the tenant attempts to comply with its covenant, hands the premises back as it's obliged to do, but the landlord takes the view the tenant hasn't complied, is a case called Simmons and Dresden, decided as long ago as 2004. The full citation will be in the notes. I mentioned Simmons and Dresden quite a lot, all the time in every situation. One, because it's a dilapidations claim which was substantial and gave rise to a number of issues that we've touched upon during the 3 webinars I presented on dilapidations, and also because I was in it, and for once I got a good result on behalf of my tenant client. But anyway, in that case, the tenant carried out substantial works, or considerable works, the judge said, in an attempt to hand back the premises. In fact, the tenant couldn't quite complete the works before the term came to an end. It couldn't quite fix the central heating boiler, I think it was. So he gave the premises back in what he said it was in repair, save for the boiler, and gave the landlord £17,500. And now the landlord wasn't very happy about all this and decided he would launch a claim against the tenant, who'd spent a 6-figure sum trying to put the premises in repair. And it ended up in the Technology and Construction Court in front of His Honour Judge Seymour, Queen's Counsel, for 5 days back in 2003, 2004. The landlord said the cost of the works necessary to put the premises in repair was over £274,000, but preemptively applying the first limb of Section 18(1) of the Landlord and Tenant Act, said that the value of it was an individual, his reversion had been diminished by £150,000, and that was the damages that he sought from my lay client, notwithstanding that the lay client had carried out substantial works of repair prior to yielding up the premises. I've got to say it, the landlord's claim was dismissed, as the judge found that he, the landlord, had suffered no loss, as the reversionary interest had not been diminished by the fact that the tenant did leave a number of breaches of covenant when the premises were handed back. So that's a hybrid situation where tenant thinks it's complied, says it's complied, landlord disagrees, and they argue in a substantial trial the difference between them, if you will. Although the subject matter is the litigation, and it really does irritate me as a litigation real estate barrister, as we call ourselves these days, to mention alternatives to litigation, but I suppose one must in the current climate. I list on the slide now alternatives to litigation. Early neutral evaluation is a possibility, but how it operates in the abstract without a framework of, for example, litigation, it's not clear to me. I've never come across it out with litigation. Again, not blowing my own trumpet too loudly, I hope. On a preliminary hearing, in the dilapidations claim, the judge offered the parties an early neutral evaluation on the issue of whether my lay client landlord had failed to repair the large windows in a converted warehouse on Wapping High Street, which was high-end apartments. And reluctantly, I think the other side agreed. I was very happy for him to do so, him being the judge. And he said that, these are my words, it's not Latin, that they didn't have a snowball's chance in hell. And the effect of that was that we never heard anything more about the claim. But that, as I say, that wasn't before litigation. That was in the context of an existing claim. Mediation, well, we all know what mediation is like. Query whether mediation is appropriate for a detailed dispute about dilapidations, unless the parties are simply arguing between, say, whether the value is £150,000 or £200,000, and so it's just a case of horse trading. Arbitration, again, quicker and cheaper than litigation. Well, it depends how it's conducted. Expert determination, again, leases often do provide for an expert determination in certain circumstances. Can't remember coming across a lease where dilapidations issues are expressly to be determined by an expert under the terms of the lease, but doesn't stop the parties appointing an expert and getting on with it. And the Royal Institution have a dispute resolution service which can be exploited. The details are on their website, and I've given the link in the paper. But put aside that possibility and get into the real world of litigation. Some preliminary considerations for the landlord. Is the landlord going to pull down the demised premises at the end of the term? Well, if the answer to that is yes, then is it worthwhile chasing the tenant for damages for breach of the obligation, bearing in mind that the second limb in Section 18(1) of the 1927 Act? And similarly with point 2 on the screen, if the landlord was going to carry out structural alterations that would render the tenant's repairs valueless, he's not going to get any damages anyway. So the landlord may think better of it. And remembering, and again, it's a point I've made throughout these seminars, that all the tenant is obliged to do under a general repairing obligation is to hand back the premises in the condition required by the covenant. The tenant's not obliged to hand back updated, modernized premises which are marketable immediately in the market that exists when the lease comes to an end, which may be a market very different from the date when the lease was granted. Commercial leases are of more modest duration than they used to be. But even now, from the date of a lease to the expiry of its term might be 10, 15 years. And the demands of the market for space, be it, for example, office space or even retail space, may well have changed in that time. So even if the tenant does hand back the premises in repair, it perhaps doesn't assist the landlord in the marketing or exploitation of the premises going forward. If the landlord does wish to pursue a dilapidations claim, a first step is to record fully and accurately the condition of the demised premises. A sensible landlord will do that before the term of the lease comes to an end. Of course, the landlord has no right to enter as of right unless there is a provision in the lease that provides for that. And any well-drawn commercial lease will so provide, usually to allow the landlord to go in and see the condition of the premises. Of course, the landlord's got to ensure that any conditions precedent to the exercise of that right are complied with, notice and so on and so forth. The landlord's right to go in and into the premises to consider its condition normally doesn't carry with it, unless expressly provided, a right for the landlord to carry out exploratory works. And one can understand that whilst the term is continuing, the tenant has the right to exclusive possession of the premises, subject to any rights reserved by the landlord to enter. And that right to possession allows the tenant to fully exploit the premises for which it's paying until the term comes to an end. And it would require very clear words, I suggest, in a lease to accommodate a landlord going into premises during the term and carrying out exploratory works by removing fixtures and fittings, for example, or making exploratory or test drillings or holes. That issue arose in a slightly different context than the case that I mentioned on the screen, the Quick Fit Properties case. I happen to be in that one myself, but for the losing landlord. So there you go, fair, if not clear. And in that case, the landlord had a right to enter into the tenant's premises, that's Quick Fit Properties Limited, to make surveys and drawings. What the landlord wanted to do once the lease came to an end was redevelop the premises residentially, as I recall. And from the defendant's name, you might understand that the premises were being used for the motor trade, as the Beatles would say. And there was concern about contaminated land and all of that. And so the landlord wished to go in and drill holes all over the place and take soil samples. And I think it was then Mrs. Justice Sharp said that as a matter of construction under the lease, the landlord wasn't able to do that. So it'll be a rare case, I suggest, where the lease allows the landlord to carry out exploratory works. Inevitably, the landlord will send in his or her expert, a building surveyor, to report. Is it a simple report or a full-blown schedule of dilapidations at this stage? Well, much depends upon the nature of the premises, the value of any potential claim, and so on and so forth. Then, armed with that information, the landlord has to decide whether, for example, it does the works. And I've touched upon this in an earlier paper, so I'll run through it very quickly. If the landlord does the works, he's going to find all the defects. The cost of the works are prima facie the landlord's loss. You remember that's the measure of damages at common law. Rather trickily, once the work's done, the building surveyor is at a disadvantage. He or she can't second guess that there was a hole in the roof or whatever it might be. Of course, that's serendipitous, because if the tenant surveyor has been in, then that advantage is lost. If the work's done, the tenant can't argue the landlord has suffered no loss. And I say in 5 that the premises would be more marketable But remember that the point I made just a moment ago, the landlord making good the tenant's repair may still only end up with premises that in, say, 2022 are not marketable because they don't accommodate the needs of modern office users. The premises are offices. Against that, of course, there are disadvantages. Landlords got to preload the works, might not have any funds. Repeating what I've said a minute ago, the premises might not be made that marketable, and the landlord may also improve the demised premises, and that makes proof of loss more difficult. It's inevitable, in my experience, for landlords to try and go a little bit further than simply carry out works that make good once of repair, but they also try and improve the premises. A point that I've made before, but it's important and sometimes very difficult to explain, or it's not difficult to explain, but to get clients to understand, the landlord is not obliged to carry out any works before it makes a dilapidations claim. Doesn't have to do that, but makes the proof of a loss different. I'm not going to necessarily say more difficult, it just makes the process rather different than if the works are carried out. And of course, the corollary of that is a landlord is not obliged to spend any damages it receives on remedial works. Oops, forgive me. Second element of this first paper, schedule of dilapidations. Self-evidently, the purpose of a schedule of dilapidations is to set out in a tabular form particulars of a tenant's breach of repairing and other obligations in relation to which the landlord wants the tenants to remedy the breach by doing works, so telling the tenant what the breaches are. If he wants the tenant to pay a sum of money, namely, these works will cost X, if you give me X, then you can walk away. Or 3, as a preliminary step in making a dilapidations claim against the tenant. Schedules are principally a matter for surveyors, for reasons that are obvious, but I go so far as to say that lawyers can assist with marrying the alleged wants of repair with the tenant's obligations under the lease. As a generalization, building surveyors are experts in identifying defects in the physical structure and interiors of buildings or other structures. They know a cracked ceiling when they see it. And therefore, without careful thought, it might be thought, well, then it's bound to be a responsibility of the outgoing tenant to make good that want of repair or that defect that Mr. or Mrs. Building Surveyor has identified. But that doesn't necessarily follow. And so in some cases, if not many cases, the lawyer have an important part to play by identifying the relevant provisions in the lease, if any, which gives rise to the tenant's obligation to make good the want of repair the surveyor has identified. Good practice is that the schedule should be served before the lease comes to an end. The purpose of that is to enable the tenant to carry out the remedial works if it wishes to do so before the lease comes to an end. Without the consent of the landlord, the tenant is not able to remain in the demised premises after the term date, even if it wishes to remain simply to carry out works of repair to put the premises in the condition required by the covenant. It's got to go. And as I touched upon a moment ago in the Simmons and Dresden case, the tenant, in circumstances which I can't remember, ran out of time and didn't do an element of the works, but offered the landlord money in lieu. The initial schedule that's served is often entitled interim schedule. As the name suggests, this title conveys the fact that the schedule served is not the landlord's final word, and other investigations will be undertaken and the schedule added to. My experience is that it's often the landlords of their hedging bets. They they're all over the premises like a bad rash, find a great many wants of repair or alleged defects, some of which are not defects or wants of repair at all, and stick it in there. But rather than pin the colours to the mask and saying this is the final word, they describe it interim. Again, this is the cynic in me. Schedule of dilapidations are often used as an instrument of intimidation, even if they are produced by experienced building surveyors. They are loaded with items of want of disrepair, often costed to a large figure in the hope that that will intimidate the tenant into agreeing an inflated figure, inflated by reference to the true breaches of covenant that exist. Indeed, I've been involved in a dilapidations case of late, which is still ongoing, where the initial approach from the landlord said that missive sent with the interim schedule saying, if you don't agree to this, we're going to go back in and we're bound to find more wants of repair, which was an extraordinary position for the landlord, an institutional landlord, to take, bearing in mind that its first inspection of the premises didn't take place until 6 months after the term date. So the premises has been lying empty for 6 months. But anyway, that's just, as I say, the cynic in me. As to the form of the schedule, I'm not going to say very much about that, because schedule of dilapidations is a schedule of dilapidations. It varies depending upon the nature and extent of the demised premises and the breaches of the obligation. We'll be looking at form in the second paper, because the form of a schedule that has to be served in the pre-action protocols is prescribed. There's usually an introductory narrative that identifies the premises, the lease, the date of the inspection, surveyor's name, the weather conditions, access restrictions. I couldn't get in here because there were experiments going on, or there was a meeting, whether demised premises are occupied, and any limitations on the survey. We didn't lift up floor coverings, and so on and so forth. After the introductory narrative, there should be a summary of the tenant's obligations relied upon, and a list of the documents the surveyor has seen and is relying upon. It's pretty bog standard stuff. The schedule should identify the breaches of the tenant's obligation, not be a schedule of works. That can often be a problem in the context of 146 notices, but that's not what we're talking about today. This is a hobby horse of mine. Unless the lease expressly provides, the tenant is not obliged to carry out tests or investigations to establish the physical condition of any part of the demised premises. It's for the landlord to prove any breaches of repairing or other obligations. I can't remember a case where I've seen a schedule of dilapidations which does not contain, at the end, usually the last group of items, a comment that the tenant needs to carry out investigations in respect of the drains to establish that they're not in breach. The tenant has no obligation to investigate anything unless the lease expressly provides. In a schedule I've looked at recently, one of the items listed under a potential breach of the general covenant to repair was the hot water pump and associated equipment under the sink at the T-point is used extensively by the tenant. That was in the column marked the breach. Now, how running water into a sink constitutes a breach of repairing covenant is a mystery to me. And the remedy for that alleged breach was to provide documentation and testing clarification of the hot water pump. Now, the pump was still pumping water, and the water was going into the sink, and you could turn the tap on and off, and it all seemed to work. Now, that was just a nonsense. Now, you might think, well, that's just a moderately amusing anecdote in the context of schedules of dilapidations, and there aren't many of them. But the landlord specified in the same way potential breaches of fire safety orders, electricity work regulations, and so on and so forth. do not be, dare I say it, suckered in to worrying one moment if a lease, sorry, forgive me, if a schedule of dilapidations is expressed in such a fashion. Ignore it. Last point I want to make about schedules is that the cost of drawing up a schedule or a pre-action schedule is not recoverable as damages, although of course there may be an express provision in the lease which permits recovery of these costs as a debt. And there's two cases there that support that proposition. The Sun Alliance case, which as you see on the screen, is a decision to the contrary, but it was fact sensitive in my view. The landlord preparing a schedule is not caused by the tenant's breach of covenant. A landlord might carry out an inspection and produce a report or a schedule, whatever it might be, which says the tenant has complied with its covenants. Can't recover the cost of that. So why should it make a difference if the tenant is? The landlord will recover the loss it has suffered, measured in the way that we discussed at a previous seminar. So those are some preliminary considerations. And I now want to talk about the pre-action protocol. The paper is quite full, so I won't spend too much time with the preliminary matters. We all know what the pre-action protocol and the Lord Wolf's report and so on and so forth. Paragraph 18 of the pre-action conduct and protocol practice direction, there is one now, specifies a pre-action protocol for claims for damages in relation to physical state of commercial property at the termination of a tenancy. This has been in force since the 1st of January 2012. I think that's my birthday. I think I was 17 at the time. Before that, there was a pre-action protocol which had been put together by the Property Litigation Association and supported by the Royal Institution. So that had been used for a number of years. And so it's quite familiar, but since 2012, it's a protocol that's been approved by the Master of the Rolls under the CPR. A few words about the purpose of a protocol. It focuses attention of the litigants on the desirability of resolving disputes without litigation, to obtain information they need in order to enter into a settlement, to make an appropriate offer, to lay the groundwork for the expeditious conduct of proceedings. That makes perfect sense. The CPR now takes protocols into account and very seriously. CPR 3.1, which is concerned with case management powers, says the court may give directions to take into account whether a pre-action protocol has been complied with. And similarly, if this is 3.15, if there has been a failure to comply with a pre-action protocol, that can be taken into account by the court when making case management orders, including in the case where a relief from sanction is being sought. CPR 44.2.5 is to do with costs and what the court can and cannot take into consideration. And if someone hasn't complied with pre-action protocol and the court takes the view that this has led to litigation which might otherwise have been avoided or to inflated litigation, they can make certain punitive, that's the right word, or negative orders as to costs in relation to the party who hasn't. CPR Part 46.1.4.14, forgive me, provides for costs only proceedings. So if everything else is settled with the parties, and indeed if one party agrees to pay the other party's costs, but they can't agree what that is, it is possible under Part 46.14 to make a Part 8 claim and have the court determine the amount of costs payable. Costs of the pre-action protocol, and I'm here talking about the protocol sanctioned under the CPR. As you'll recall, Section 51 of the Senior Courts Act, as it's now called, provides the costs of and incidental to court proceedings are in the discretion of the court. In this McGlynn case, costs incurred by a party complying with any protocol are capable of being costs incidental to any proceedings which are subsequently commenced if the protocol procedure fails to lead to an early settlement. In that case, in fact, the costs weren't recoverable because the landlord advanced in its schedule a number of items which were abandoned before proceedings were entered into, and therefore the judge in the McGlynn case didn't find that the costs of preparing the schedule to that extent was incidental to court proceedings, because those alleged breaches which were abandoned were not pursued. As to the specifics of our protocol, it applies to England and Wales, and it only applies to damages claims at the end of the tenancy. And as I say, it came into effect in January 2012. The purpose of it, much of what we've spoken about, a reasonable process and a timetable for exchange of relevant information, sets a standard for the content and quality of schedules and qualified demands, establishes a process and timetable for the conduct of pre-action negotiations. The CPR make it clear that, and the decisions that have been made on the operation, the relevance of protocols, that what the courts are looking for is substantive and bona fide compliance with the requirements, and technical failures to comply with each and every word of the pre-action protocol will not prejudice a party. In our pre-action protocol, there is no definition of repair, dilapidations, reinstatement, or redecoration. First blush, this might seem a little odd, but of course, those words, albeit that we're all familiar with them, take their true meaning from the color of the instrument in which they are to be found. And as the pre-action protocol applies to any dilapidations claim in commercial premises at the end of the term in England and Wales, it would be wrong and unhelpful, and indeed unnecessary for the authors of the protocol to define any of those terms. The general aim, you can imagine what they are: cards on the table, full and frank early on, avoid litigation by seeing the strengths and weaknesses of the other sides, and support efficient management if litigation does go ahead, similar sort of stuff. There's an X to the protocol A, what they grandly call a flow chart, which I say is a list. And say for the odd words, which I think the cat put in at the beginning in the red bar, that is it: send schedule, send qualified demand, send tenant's response, negotiations, quantification of lot, stock take, court proceedings. So those are the steps in the pre-action protocol. The form of the schedule is prescribed, and as I mentioned just a moment ago, the protocol does aim for consistency, both in form and in the standard. The form are annexed as A or B. In fact, it's B or C. B is that prepared by a surveyor. C, if prepared by the landlord. There isn't much difference between the two, and I put copies of B and C at the end of the paper. So insofar as you're interested, you can have a look at that. It prescribes that the breaches are divided into categories. So it'll be decoration, plasterwork, floor coverings, whatever. The schedule should also specify or refer to any notices that were served in respect of reinstatement, notwithstanding that, as we all know, an obligation to reinstate is not the same as an obligation to repair, but the two overlap significantly, or arise at the same time, if that's the right way of putting it, and therefore it's right that it is included in the schedule. The schedule can be given before the end of the tenancy, makes sense, and if so given, the landlord must confirm at the end of the tenancy that the schedule of delapse describes the position or a further schedule should be given. So that it's attempted to eliminate the difficulty, the frustrating difficulty I identified a while back, namely the interim schedule, which is inflated in order to intimidate. In terms of the timetable, it must be given within a reasonable time. Whatever reasonable time is fact sensitive, but it does prescribe that 56 days after the end of tenancy will normally be a reasonable time. Of course, depending upon the nature and extent of the alleged breaches, what is a reasonable time will differ. And the schedule must contain an endorsement either by the landlord or by the surveyor, depending upon who puts the document together, essentially prescribing that what is said is true. So the landlord must endorse, the landlord's surveyor must endorse that the breaches are reasonable, that the costs are, that if it is costed, are reasonable costs, and so on and so forth. The qualified demand is another element which the landlord prepares, and it's sent with the schedule, which we've just looked at, and that sets out in a more narrative form all aspects of the dispute in clear terms. And if there's some money sought as by way of damages, the sums must be substantiated fully. Must confirm that the landlord's surveyor or the landlord itself will attend meetings and engage in negotiations, and specify a reasonable time within which the tenant should respond. And that's usually 56 days again, but of course that's fact sensitive. So thus far, the pre-action protocol requires the landlord to do all that. The next step, as revealed by the flowchart, is the tenant's response, and that's produced by the tenant and given within 56 days of the tenant receiving the landlord schedule and quantified demand. Clearly, the tenant should use the landlord schedule of delapse to respond. And indeed, it's not a requirement, but it's advisory that the landlord schedule be sent to the tenant electronically to allow that to happen. The response equally must be endorsed by the tenant or its surveyor, that it's legitimate and honest and truthful. And the tenant must identify any superstition which it says will arise out of the landlord's proposed works. And we discussed what superstition is in the previous seminar. It is essentially works which the landlord intends to carry out, which would render the tenant's works valueless. The disclosure of documents prescribed by the protocol is limited. It should ordinarily be just those referred to in the quantified demand and the response. That could be specifications, estimates, tenders, and so on and so forth. Of course, the parties can agree to give further disclosure. Pre-action disclosure is always available under Part 31, but the protocol urges the parties to behave in a manner which means such an application is to be avoided. I can certainly say that's a good idea. The next step in the procedure prescribed by the protocol are negotiations and meetings. My experience is the bulk of dilapidations cases are settled as between surveyors, building surveyors acting reasonably. And the protocol encourages landlords and tenants to meet before the tenant is obliged to send the response, and meet again 28 days after the tenant has served the response. All these meetings are should be expressed to be without prejudice. ADR, I attended a Chancery Property Bar Association event recently, and the president, Mr. Justice Fancourt, said that ADR is not ADR, it's not alternative, it is mainstream these days. So the protocol encourages the parties to engage in what we used to call ADR, and therefore avoid litigation. If none of that works, If the parties are still at odds before the landlord issues proceedings, the landlord should quantify its loss by providing the tenant with a detailed breakdown of the issues and consequential losses based upon either a formal diminution in value valuation or an account of the actual costs of works carried out, or a combination of both. The formal diminution in value valuation is Section 18(1) valuation, namely that valuation that shows the difference between the value of the landlord's reversion with the tenants, with the premises in repair, compared with the value of his reversion or her reversion with the tenant premises out of repair. So that arises where the tenant is not obliged to, the landlord doesn't intend to carry out any works. In this quantification of loss, if the landlord doesn't intend to carry out any work, the landlord must identify those which he is, if he's going to do some, when he's going to do them, what steps have been taken towards getting the proposed works done, clearly show the scope of the proposed work and any effect it would have on the dilapidations claim. What's aimed at there is that the landlord is obliged to reveal whether the works that it proposes to carry out would, for example, engage the second limb of Section 18(1) of the 1927 Act, structural alterations which would render the tenant's repairs valueless. In such a case, the tenant is not obliged to pay any damages, or put it the other way, the landlord's not entitled to recover any damages in such a case. Where the landlord hasn't carried out all the work specified in the schedule and doesn't intend to do that, then Section 18(1) valuation must be served with the quantification of loss, unless it would be unreasonable to do so in all the circumstances. So picking up on the considerations we spoke of a moment ago, that there may well come a time, if a landlord doesn't do the works, where he's got to put his hands in his pocket and have a valuation carried out. And the contrary of that is also true. If the tenant relies upon a defence based upon diminution in value of the landlord's aversion, in other words, relying upon the first limb in 18(1), it must state its case for doing so and provide a diminution in value report. The report should be given to the landlord within a reasonable time, and again, 56 days after the landlord's detailed breakdown of loss will be a reasonable time. The final element in the step, if you will, in the pre-action protocol is for the parties to take a step back. It's called stock take, and consider the material to be exchanged to see if the litigation can be avoided. And if that can't be done, at least to narrow the issues. And although it's self-evident, that's a very sensible stage, because the blood is often up at this stage. But one should have regard to what's the difference between the parties. If it's just money, compare that to the amount of money that we spent with experts, solicitors, and very expensive barristers in court arguing a dilapidations case. They tend not to be disposed of in short time when we get into court. The final paper I want to talk to you about this afternoon is concerned with litigation itself. This is not a class, never mind a masterclass on how to conduct litigation. We all are familiar, or to varying degrees, with the rules of court and so on and so forth. But I want to highlight certain aspects which are particularly relevant to dilapidations cases in the last 10 minutes or so that we've got. Jurisdiction. The CPR apply to dilapidations claims. There's no magic in a claim for damages for breach of repairing covenant. The High Court, Queen's Bench or Chancery Division, and the County Court have jurisdiction. Inevitably a Part 7 claim. I can't think of a dilapidations claim that would be suitable for a Part 8 claim. Perhaps if there was the only issue between the parties was the interpretation of the clause in a lease, that might be, but I've never come across such a case. So it's a Part 7 claim, and the Practice Direction 7A applies. That tells us that if a claim is worth £100,000 or less, it's got to be in the county court. I suggest that even in 2021-22, a dilapidations claim worth £100,000, or in excess of £100,000 is quite a substantial claim, and therefore you'll see that the county court's jurisdiction in respect of dilapidations claims, and this financial limit is not limited to dilapidation claim, is extensive. That maybe some of you who remember when the jurisdiction of the county court was £5,000, but that was a long time ago. The Technology and Construction Court deals with a lot of dilapidations claims. The Simmons and Dresden case I mentioned earlier, that started out in the county court. Simple claim for the tenant for overpaid rent. The landlord Part 20 counterclaimed for £150,000 worth of delapse, as I've mentioned, and that was transferred to the TCC. The jurisdiction of the the procedure of the Technology and Construction Court is prescribed by CPR Part 60. Essentially, the TCC will get its grubby hands on a dilapidations case if it involves issues or questions which are technically complicated. You'll know, of course, that the TCC deals with building disputes and disputes about computers and software and all of that. And in some dilapidations cases, there may be some technically complex issues, not so much whether there's a hole in the roof or the brickwork needs repointing, but for example, with plant and machinery, with, dare I say it, in these days, with cladding and the skins on buildings, and so on and so forth. So there are cases where the issues that arise in dilapidations cases are complicated, and it might be thought that the Technology and Construction Court would be appropriate for that. There's technology and construction courts, if you will, or judges, both in the High Court and in the County Court and in the district registries, and therefore that jurisdiction is available to all of us all around the England and Wales. There's a TCC guide. It dates from 2005, but it contains helpful guidance on the operation of the Technology and Construction Court, and I suggest that you read it or parts of it if you believe that your case is best dealt with in that jurisdiction because of its technicality and complexity. Summary judgment. It's a rare case, I would suggest, where summary judgment is appropriate for the disposal. Dilapidation case is suitable for disposal by way of summary judgment. As you know, the jurisdiction can be exercised where the claimant has no real prospect of succeeding, or the defendant has no real prospect of successfully defending. It'll be a rare case, I say, when that will be appropriate. It's been suggested the case may be within suitable summary judgment where the tenant is relying upon the second limb of Section 18(1) of the 1927 Act. So if there's compelling evidence that the landlord is going to pull down the demise premises at or shortly after the term date, well, that's a matter of fact. But then it's easily defeated by the landlord saying, oh, no, I'm not. And so the master will be, if it is a master, will be faced with witness statements in conflict, and that can't be resolved at the summary jurisdiction stage. I repeat, often these days, an application for summary judgment in any case is time not well spent, and certainly money not well spent. Scott schedules, they're often, well, that was the same slide. Scott schedules are often ordered to be produced as a direction in dilapidations cases. We've touched upon schedules earlier. The Scott schedule, named after that judge, I wonder if he had a different name, it made its name into the title. But anyway, as I say, the courts can order make a case management direction that a Scotch schedule be produced. The TCC guide provides information about the formulation and content of a Scotch schedule, and they are useful in litigation. Again, in the Simmons and Dresden case, the judge made the point that there were 162 items which were in issue, and it was so convenient to have those issues in one document, which all those involved, the judge, counsel on both sides, and the witnesses, could look at and refer to and mark up as they were going along. So Scotch schedules are a useful tool in the tool bag of case management orders that can be made. They also lend themselves to specimen items. So one might have any number of items dealing with the standard of decoration that the tenant has or hasn't undertaken in the premises, rather than deal with the decoration in rooms 1, 2, 3 through to whatever it might be in ceilings and walls. A specimen item can be chosen, and that can be litigated, and the result applied to all the decorative items listed in the schedule. Expert evidence is crucial in dilapidations cases. You're familiar with Part 35. The whole goal is to limit expert evidence, but in dilapidations cases, as I say, almost inevitably an expert will be needed. Content of a report, there's guidance in the rules, qualifications, the literature that's relied upon, setting out the substance of facts, and so on and so forth. Make clear the facts stated important, the expert's own knowledge. Can't stand reports that say that we did this, we did that, we did the other, or my firm did. Who had the feet on the grounds? And as 5 identifies, if it's a collaborative effort, then the authors or the contributors must be and should be identified. If there's a range of options on the matters, they should fairly summarize those and give their reasons. If an expert is not able to give an opinion without qualification, must state what that qualification is. My own view is that these days experts' reports are, for the most part, CPR 35 compliant, and experts are now careful with the content of their report. It's now not possible unless one presents a credible reason for doing so. It's not permissible under the rules for an expert to be cross-examined or asked questions by the other side about his or her instructions. That used to be a favorite of mine because nobody used to say what their instructions were. But that's not permissible now unless there is a factual basis upon which one can justify the questioning, which is a bit of a shame. And with experts, it's always important that one establishes whether or not they have looked at the relevant material. They inevitably will have looked at the lease and maybe will have understood it. But if there's some statutory provision, for example, that impacts Section 18, if they don't refer to it, then that's a striking omission, in my view. Not necessarily an evaluation report, because that would be disastrous. But it's always worth asking the expert to confirm that they have, particularly when they haven't referred to it in the report. And of course, if the answer is, well, I have, and then why didn't you write it down? It may well be that the expert's credibility or his confidence or her confidence is shaken before one even gets to the substance of the report. That's all I need to say, or I'm going to say, about litigation. As I say, it was a bit of a snapshot because for the most part, the litigation process and dilapidations claims is much the same as it is for any other, but I've highlighted, I hope, some more of those. issues that are germane to dilapidations claim. Thank you so much for attending this afternoon. This is the last webinar for 2021, for me at least. I do propose to put series again for next year, and I hope that there'll be something of interest and you'll join me, and I hope you keep well, and hope to speak to you soon. Good afternoon, everybody.